distinguished guests, dear students, I'm very grateful to be at this conference. I thank the organizers and my colleague Indra, who invited me to this conference. And maybe my presentation will not be so broad. I just, when I look for the theme of the conference and the word was paradoxes, I choose some paradoxes from Slovak development of mediation because we are not so far to speak, or yeah, we are speaking about mandatory mediation, but we are not there yet. So maybe I can present you some paradoxes, what we faced, and maybe to show where not to go. Okay. So my presentation will be about Act on Mediation, which, as I heard, we have the same year of implementing it, 2004, so it was quite a long time ago, and about these paradoxes in the development of mediation in Slovakia, which maybe this 20 years brought, because next year we will have 20 years. So we can celebrate it or not. I will answer, or maybe I find answers after this conference. So only very few information about previous acts. So we are in the year 2004, and this legislation was quite easy, quite simple, not easy, simple. Sorry for my English sometimes. Act on Mediation was based on UNCITRAL model, and it covered all basic principles: impartiality, voluntarity, confidentiality. Agreement to mediate was only written contract, maybe put just in minutes at the mediator's office. And from the beginning, mediators were registered by the Ministry of Justice after a compulsory mediation training of 100 hours, but not for lawyers. Lawyers had only consecutive 3 days. It was very strange. We have not so much time to explain why this happens, but it was other paradox. And exams for mediators were part of the training. Mediation settlement agreement in 2004 was in written form, possible to become enforceable via court or arbitration court or notary public. As you see, the law from 2004 have only 5 pages. You see it in the upper corner, 5 pages, but it changed as well civil procedure law. And from 2004, the court can recommend to parties to try to reach the reconciliation by mediation, from 2004. But in the beginning, there were bright ideas, and we all thought, because I'm one of first mediators, I passed my exams just after this act come to effectiveness in 2005. So we thought that legislative definition will strengthen the position of mediation. Mediation will be serious alternative to court proceedings. University degree and mediation training will ensure quality. Mediation will be a new profession. Legislative definition of mediation centers will open new possibilities because mediation center will be open all over Slovakia. And we thought at that time that UNCITRAL basis applied to facilitative model, as maybe you know, that it may fit for everything. So this was the basic, facilitative models fit for everything. But what happens and what I see now, like the paradoxes from the first years, that this legislative definition in fact destroy informal mediation practice, because everything when the third party helps to people, we called mediation. And because it was written that mediation can be held only by the Act on Mediation. Everything should be mediation in the formal procedure. So mediation projects which were applied before this years 2004 and after, unfortunately, were not able to start an effective cooperation with judges despite the fact that the law recognized it. So the court-referred mediation. A facilitative model with too little law, I think it was obstacle for lawyers because they didn't understand that this is the main characteristic of mediation. They were still asking how mediators cannot be lawyer, should help us to solve a legal dispute if they are not lawyers. So they didn't understand it. And unfortunately, because non-pay mediation was not allowed, this business activity was obstacle for judges to recommend mediation because they say if the parties have to pay for it, we will not recommend it. I think it's the same like everywhere. And this uniform form of mediation for all areas of law and all types of cases, I think, didn't help as well in that time. And it is still up to date. And the easy way to obtain the license, especially for lawyers, led to low quality. So this is maybe notion that even if you have 100 hours compulsory training, it's not enough. Unfortunately, what was other paradox that Directive of Mediation Directive, which has the main goal to support mediation in EU countries, in fact, in transposition to Slovak law, not only failed to support mediation, but in fact, it complicated it and made it almost unworkable for next year. So what should help? It didn't because, and I wrote it, so to preserve the requirement that mediation must be intended to suspend the running of limitation and prescription period, the legislative have decided that any agreement to mediate must include officially certified signature of parties, and all agreements to mediate should be registered in Notary Public Register of Document, which was charged. You can read it. It was charged quite sometimes it was expensive, and it was very complicated. So all these conditions, in fact, in 2010, stopped conducted mediation according to the law because it was impossible. So some people continue to do it, but they call it facilitation or just another names. So mediation stopped. And as you see in these very little letters in the bottom, it is that we started to write agreement to mediate in very little letters because we need to pay €5 per one page. So we started to write it, it was almost impossible to read it, but what should we do? Okay, so, and every amendment to the Act on Mediation, unfortunately in Slovakia, just formalizes the mediation more and more, because from 2016 we have new amendment effective, which fortunately stopped this registration and certified signatures, but it brought new provision, and so mediators need to fulfill more and more conditions. And now the Act on Mediation, as you see, have 12 pages and is still more and more complicated. Mediation is more and more informal, less informal and more formal. Another paradox, and I will skip it very quickly because it is just maybe interesting to know, that we have a very big number of registered mediators. So I will not explain why it goes up and down, but even without mandatory mediation, without no court-referred mediation in practice, we have really a big number of mediators, and our Ministry of Justice started to fight against it. For example, now from year 2016, we have 200 hours compulsory training, and you need to go one time a year to compulsory one-day seminar. If you don't go there, ministry will ask to do examination, and if you don't pass examination, you will delete it from register. But still all this changing in law doesn't happen or doesn't help. It helps because many mediators means that we are many of us. I will skip this. But what is important, and it is conclusion from our research we did at the project of Ministry of Justice. It was project with court-referred mediation, but I put the data about this number of mediators from it. And this is the realistic number from the research. So as you see, 27% of mediators who were part of the research has 0 cases through all the length of the practice, 0. And as you see, it is 118 respondents from all the number of 800. So if I count it like hypothetical number, from November 2023, we have 955 mediators, and if I count it, it is hypothetical, of course, but maybe 3/4 of mediators has completely 0 practice, no one case during all the length of practice, and maybe 1/3 or 1/4 have maximum 10 cases. So there are, but there are really a few people. We can count it maybe on 2 hands and maybe fingers, toes. But yeah, there are like 100% full-time mediators. They exist in Slovakia, and they are more and more. And what I'm happy when I teach at the university, I'm teaching the mediation clinic, and when I ask my students why they choose the mediation clinic, they say, maybe I want to be a mediator after I finish the school. So for me, it's like new idea to be a mediator just after the faculty of law, but it's nice, and I think it's hope for the future. I have a more presentation prepared, but I have only 2 minutes, so maybe only I will show you. This is a concept of our civil procedure code now. So we can courts can recommend mediation in different cases. But maybe what is the more important for me, like to build more and more amendments to law and to build more and more formalism to mediation, is really solving financing of mediation service, because there is almost no unpaid mediation. We have, of course, some possibilities to pay for mediation for people with very low income, but there are not many possibilities to have unpaid mediation. We need to build maybe, but because you see, I put there question mark. I don't know if it is good or not, but we need to talk about it. So talk about specialization, maybe fight against formalism of mediation, find some solution about functional system of court-annexed or court-referred mediation and informative session, maybe talk about mediation centers, because majority of them have only 1 or 2 mediators there, so one have 5, and it is the biggest one. and the minimal support of mediation from Ministry of Justice. I think it's a problem because we have one person who is responsible for register of mediation and all the stuff, and that's all. So not 30 in Turkey and all the departments. There is a department about criminal mediation in criminal cases, but not in civil. So, but next year, happy 20 years, and I hope a bright future is waiting for us. So, thank you very much.